Hi, my name is Felina Rivera. I'm the managing partner here at Renaissance Legal Solutions. This is Nathan Richter, and he's an awesome attorney we've got working here at Renaissance as well. And we wanted to go over the cannabis legislation, the newly proposed cannabis legislation that's been proposed with you. I do a segment with the Oklahoma Bar Association and share this information with other attorneys in the state, and really see that there would be a value in sharing this information with the general public, especially those business owners involved in this industry that is ever changing. So we've done a brief summary of all of the newly proposed bills for 2024. So this is right now, we're in the second regular session of the 59th Oklahoma legislature. In 2023, it was their first session. So there are some bills that rolled over and are being reintroduced this session as well, or are up for consideration. And we'll go over those in another segment as the legislative season progresses. I suspect some of those are going to die. They didn't really go anywhere last year, and I think that'll probably end up being the same thing this year. But for now, we're just going to focus on the newly proposed legislation here in 2024. And then, Nathan and I will kind of discuss some of the effects we see, the good, the bad, and how that might affect you and your businesses. Also of note, there are about 10 shell bills. What that is the House of Representatives has the ability to essentially reserve a spot for a bill that they're proposing. So House Representatives Newton, Rowe, Marty, which I'm not familiar with some of these, they must be new, Van Kuren, Kennedy, Davis, and Munson in the House of Representatives all have shell bills referenced as the Medical Marijuana Act of 2024, but there's no substance yet. But we can anticipate that there will be something proposed there. There may be lobbyists to reach out to those senators later in the session for some language to be proposed. So those are just of note for you. In the House, we have two bills that have been proposed so far that have some language to them. The first one is House Bill 3355, proposed by House Representative Marty. This would amend Title 63 OS Section 426.1. That's where you're required to provide a certificate of compliance. Now, an affidavit stating that your premises still complies with zoning classifications and all applicable municipal codes and safety building codes, etc., would be required instead of a new certificate of compliance. The law right now doesn't require that you do a new certificate of compliance. This is really, and I think actually, if you go onto the licensing portal right now, you already are submitting an affidavit saying that there's been no change of use. This seems to maybe change the language a little bit more and probably related to the certificate of occupancy issue that's going on to just make it where you have to essentially verify that you're complying with building codes.
Yeah, and this bill mirrors a similar bill that's pending in the Senate, Senate Bill 1634, also requiring affidavits regarding licensed premises and that they still comply with your applicable building and zoning codes and requirements. And so you're going to see similar language on both sides, and I kind of want to circle back a little bit. When Felina was talking about a shell bill, oftentimes these shell bills are used towards the end of session to sort of consolidate a lot of other bills that are relating to cannabis, and then they propose it under a medical cannabis or medical marijuana act, as they've mentioned here. So shell bills are important to at least pay attention to, because while they don't have necessarily any language in them now, they may ultimately become a vehicle that the legislature uses to push through some of these other, the bills that may die in committee or otherwise.
Right.
So,
right, they may all get combined into one larger bill under these shell bills. Yep. Now, additionally, in this proposed bill, and I think it's also the same in the Senate bill that you referenced, it also permits municipalities to implement an inspection program to verify their compliance. It says OMA will create a affidavit form for this subsection, and it will be authorized to suspend operations of a licensee for failure to comply. One thing that was interesting when I was reviewing this is that it it is a may. So that means that the municipalities may implement it. It's not required of them. So if they do end up implementing it, though, then that would give OMMA the authority to then suspend your license if you aren't in compliance with this. And I did want to also reference that on this certificate of compliance section that we just talked about, that it already states in the law that you have to conform with uniform building codes in Oklahoma. So I find a lot of this stuff to be redundant. We already know that you have to do that. And so I don't know if it's just to, further push the point or what, but you already are required to conform with uniform building codes in Oklahoma.
So I think the big distinction with this particular bill is that right now, if you're operating in and around Oklahoma City or Tulsa, Oklahoma City code enforcement can come and inspect your business and make sure that you're operating your business within the confines and the rules and regulations of our Oklahoma City code. Same for Tulsa, same for a lot of other bigger municipalities around the state. What it doesn't do or hasn't been allowed to do is if Oklahoma City comes to your business, finds that you're operating outside of the code, the Oklahoma City, for example, doesn't necessarily have authority to shut you down.
Right.
Now, this bill would allow them to tell the OMMA, who the OMMA could then issue proceedings to suspend your license and stop operations until you become compliant. And that's I think, the big worry that most operators in the business and in the industry need to worry about and be concerned with.
Yes. So that is on the proposed bills, and if it passes, it would be effective in November 1 of this year. The next substantive bill that's been proposed in the House is proposed by Representative Moore, House Bill 3458. It pertains to taxes, so it actually amends the tax statutes. It authorizes tax information that is obtained by the OB&DD or the district attorney or the AG's office, the Attorney General's office, to be used in prosecution of violations of money laundering under criminal statutes found in Title 21. The language of the proposed bill, it already allows the prosecution of other crimes. It just adds money laundering as one of the crimes that this information can be used to prosecute. And I know, I suspect, and just from our experience, there have been countless investors who have lost their money in this industry in Oklahoma. The industry, I think, has unfortunately used shell corporations and I think sometimes inadvertently laundered money through companies that weren't cannabis. And so I think it's something to just be very cognizant of and aware of. You may need to seek legal counsel to make sure that your businesses, especially if you have more than one entity, are structured properly, because you may inadvertently be laundering money, and this bill would allow for criminal prosecution of you if that evidence is found in your tax information. So.
Yeah, two things guaranteed in life, right? Death and taxes. And
Right.
taxes are something you should always pay attention to. Make sure you know where your money's going, why it's going, where it's going, and account for it. Have justification behind it. Make sure you're working with a CPA that's frankly familiar with IRS Code 280E, some of the other regulations that apply to how cannabis operations are taxed, and make sure that you're applying those categorizations and these classifications within your finances appropriately. Otherwise,
Right.
You're at risk of criminal prosecution for tax evasion, money laundering, and a whole host of other things.
And I think that there is already a risk of some of this, at least with the IRS audits and financial penalties, but this really brings it to criminal penalties that can include jail time. And it brings it to the state level as well. And so it's more important than ever that you make sure if you have multiple businesses, you seek counsel from an attorney, a CPA, to make sure that you have all of your businesses properly structured, that there is separation between those businesses, that you are using separate CPAs, separate accountants, separate email addresses. They have to be separate entities and be ran properly and have proper arm's length contracts between them if you're doing business among your businesses, and all of those things are things that will help protect you from this, and things that attorneys like ourselves can help you with. So just be aware of that. And if this passes, it would be in effect immediately. An emergency has been proposed, which means that if it passes, the legislatures also vote on an emergency separately. And so if that also passes, it goes into effect immediately upon passage.
Yeah, one good reminder for everybody out there that if a bill is not an emergency, nor does it have an effective date in the proposed legislation, it automatically becomes effective November 1st of the year it was passed. So if the bill doesn't have a date in it where it says effective, January 1st, and it was not an emergency, it wouldn't become effective until November 1st of this year. But because this one is an emergency, it would become effective the minute the governor signed it.
Right. There was a bill passed related to the moratorium a couple sessions ago that sort of jumped the gun on that. They tried to indicate it was going to be in effect less than 90 days after Sendai, which is when the legislative session closes. And because it had a specific date in it, it was able to go into effect 90 days after, not November 1st, but it couldn't go into effect at the date it had indicated originally because it was before that 90 days and no emergency had passed. So I know that got brought to the attention of OMMA and everybody got a couple extra weeks to apply, but good to know your legislative procedure for things like this and hold the government accountable when they try to overstep. Okay, so moving on to the proposed Senate bills, there's quite a few more. And again, there's some rollover bills from last year. We'll go over those in a separate segment, but these are the new bills proposed for 2024. The first one is Senate Bill 1219, proposed by Senators Stanley and McDougall. It would actually amend the requirement that patients renew their license every 2 years. It would lengthen that to every 10 years, and that would go into effect November 1st. I see no negatives with this. I think that's great.
I see no negatives at all. I think this is fantastic. It's going to save people, frankly, time, money, resources to renew their license every couple of years. And while that process is not overly complicated or complex, it is kind of a pain to have to take out your time and go get your picture and get all the information.
Right,
so
yeah.
Extending it out for 10 years is good for the patients and it's good for the industry.
Yeah, I agree. Senate Bill 1247, proposed by Senator Burns. This would require, this is sort of a bizarre proposed bill. To me, it's a little excessive. It proposes that businesses, medical marijuana businesses, list each building trade contractor's license number or employee information to perform work on a building being constructed for use as a medical marijuana business. It requires compliance with the Oklahoma Uniform Building Code, which and then it authorizes OMMA to enforce it, which right now it's under the purview of the state fire marshal's office. So it's, we have this overlap of government agencies having, multiple powers. It seems a little, again, excessive, and whose jurisdiction is what, right? And then it requires applicants to post an entrance on your building prior to commencement of construction, a legible sign displaying the name of the trade contractor and all applicable Oklahoma license and registration numbers for each contractor permitted to work on the premises, or a contact for the responsible party who has that information to provide. So it's, again, just this desire for transparency and if you're going to work on this building, the thing that I'm thinking about is, if you build a building, do you necessarily know it's going to be used for marijuana on the front end? You may not. You may not build it and then end up renting it to a medical marijuana company. I mean, it just seems bizarre.
This is a bizarre
overreach.
It's a bizarre bill. I think what bothers me most about this bill is it requires the licensee to list every trade contractor that might work on the premises. And if you go out and hire a general contractor and that general contractor then hires 7 different subcontractors, now you're having to chase down the information through your general to get the subs, to post it on a sign. It just seems really unnecessary when you have a general contractor who's maintaining all of that information anyways.
Right.
It seems like it would be more reasonable to just have the general contractor post their information and permitting information, which is typically required, believe it or not. If you have construction, all of that information gets submitted to the permitting departments for wherever you're building. And typically it's posted somewhere on the premises
so
of the construction site.
So it's not like you can't find the information
Correct.
already.
Correct. This one seems to go a little too far in my opinion, because now it's requiring the licensee to go get information from the general contractor rather than, letting the general contractor do their job.
Right, yeah. No, and it just is, to me kind of shows a lack of understanding of building codes in general and how the whole process works.
Yeah.
So it just seems unnecessary. But if it passes, it would be effective November 1st. Senate Bill 1286 has been proposed by Senator Bullard. You guys are going to love this. It adds an annual surcharge of $1,000 to every single medical marijuana business licensee. 500 would be allocated to the county sheriff public safety grant revolving fund, and 500 would be allocated to the Oklahoma Tourism and Recreation Department revolving fund. So you tell me, do you think this might be considered a tax?
It might be. I mean, we're talking about more money that we're going to take from licensees and apply it to government agencies.
That have nothing to do with the cannabis industry.
And for what purpose,
right,
other than to fund another agency. Really doesn't seem like this is really related to cannabis, particularly with the Tourism and Recreation Department. I mean, remember, we don't have a recreational program here. So
right.
Well, people that are tourists aren't going to be able to come into Oklahoma
right.
and buy cannabis while they're here for a day or two until we have a recreational program. So it seems a little bit askew,
right,
of really where it's
just a money grab. I mean, that's what it
sure
seems
feels like it.
Yeah,
sure feels like it.
And from our research that we've done in our case that's pending against the state on the tiered licensing bill, one of the arguments we're making is that that fee was disguised as a fee rather than a tax. It's a tax disguised as a fee. Here, I kind of think we have a surcharge. Or a surcharge fee disguised.
A surcharge,
right.
That's really a tax.
It's really a tax. And one of the things we've learned through that research is that, the fees do have to be related to the services provided in that industry or in that agency for them to be fees and not a tax. So I think this bill runs the risk of a legal challenge if it passes. But if it does, it would go into effect November 1st as well. Senate Bill 1289 has been proposed by Senator Garvin. It seems to only change the language of how point of sale tax that is collected is allocated to the Oklahoma Tax Commission. I believe the current language says that it is then passed to the OTC versus here it says it's retained by the OTC. So no real substantive change, I don't believe. It's always been not always, but at least the last few years, it's been a 1.5% amount that is being allocated to the OTC from those point of sale purchases. So I'm not sure, it might just be a cleanup bill.
Yeah, this seems like it will have zero impact on the industry
Business
at large.
Owners,
yeah, zero impact on business owners.
Senate Bill 1352, proposed by Senator Bullard, actually proposes a brand new law rather than changes to existing law. It establishes, it's pertaining to water, so it establishes the Reservoir Capital Investment Fund. It creates the Water Sustainability Revolving Fund, and it would allow municipalities and counties to impose water usage fees for commercial medical marijuana growers. The rate would be $1.25 per every 1,000 gallons of water used. And then the revenue would be split between the local authority and the Reservoir Capital Investment Fund. Now, counties would not be able to collect secondarily to municipalities that establish this fee. So if you are in a county and in city limits growing, and that municipality, that city implements this fee, you would only have to pay the municipality. The county could still have a fee, and if you're outside of city limits, then they would be able to collect it, but you wouldn't be liable for both. So, but that, and I think we saw that coming. I've seen the last few years a few bills and heard legislators talking about the need for water usage fees. So I'm not really surprised by it. It will affect you, but I don't know that we can get around. I mean, I think this is just an inevitability.
It could very well be inevitability. I mean, especially considering some of the historical problems Oklahoma has seen with water, particularly in the western side of the state.
Right.
So this seems to be a bill to address that, probably a long-term plan by the legislature.
Yeah, and it doesn't seem terribly unfair. So
No, it doesn't. I mean, I don't know what the current rates are and the increase here, but water is a problem, and we all have to have
Right.
it. And water, particularly with grows, water has been an issue really from the beginning.
Yeah.
So this is a bill that cleans a little bit of that up.
yeah. Okay, moving on to Senate Bill 1549, proposed by Senator Boren. This is an amendment to the criminal statutes, Title 21. This deems knowingly exposing children to secondhand marijuana smoke a felony. It would make you guilty of child endangerment. I think this is something that you definitely should be paying attention to. It is supposed to be considered medicine. As far as I know, there is no felony, criminal liability, or child endangerment charges that can be brought against you if you expose your children to secondhand cigarette smoke. But
Right.
this makes it to where secondhand marijuana smoke is a felony. And one thing I didn't include in the summary here is that when I was reviewing the bill, it indicated that if a child tests positive, a minor tests positive for THC in their system, that could deem the parent guilty of a felony. And I brought up the point in our OBA section. Well, what about curious teenagers? I mean, since the '60s and the introduction of marijuana,
Yeah.
like you've got teenagers who are experimenting. We don't keep track of our children 24/7 a day. If your teen is 17 years old and they go get high with their friends and you have no control over that, there is still this risk. If they can prove this knowingly element, that you're guilty of a felony. So this is one that is probably of great concern. And so if you have comments on it, it was Senator Boren who has proposed this bill. Yeah.
Yeah. This bill seems like the intentions might be good, that we want to obviously protect the health and welfare of our children. Great. But the enforcement of this really seems like it's going to be problematic. If you're in a park, for example, consuming cannabis with your valid patient license and your child happens to be standing 10 feet from you, are you knowingly exposing them to secondhand smoke? We can come up with different situations and circumstances and argue kind of, does this apply or does this apply? But that's the problem with this bill.
Yeah.
That and, where they're focusing on marijuana and not so much cigarettes, which we all know cigarettes are a problem. So it seems to be a little biased towards the cannabis industry.
Of course, because we've got this remaining stigma that we're always having to battle. So anyway, if that passes, it would go into effect November 1st. Senate Bill 1634 has been proposed by Senator Coleman. This is also a new law. It would require all flower, shake, trim, keef, and other flower-based products not defined as concentrate to be sold by processors and growers to dispensaries only in prepackaged form, weighing no less than half a gram and no more than 3 ounces. We've seen something like this proposed pretty much every last couple sessions, I know, and here we are again.
There's pros and cons to a prepackaged bill. We had a prepackaged bill last year that I believe might be a carryover this year, but the industry seems kind of split on it. I'll tell you from one perspective, prepackaged flour can be a good thing, in the sense that we know that it's when it was packaged and tested and it's not been, contaminated or adulterated in any way when it gets to the dispensary and it's sitting on the shelf, so that we know when the customer buys it, it's largely in the exact same form it was when it left the grower or the processor. Mm-hmm. On the flip side, our nose with cannabis is our greatest asset, and not being able to see or smell the flower before you purchase it is obviously a detriment to the patients out there. Mm-hmm. And so there's some pros and cons to it, but we've seen prepackaged bills now for 2-3 sessions, and it seems like that's a big focus for the legislature.
Well, and one thing that this actually impedes on is the existing right of dispensaries to do their own pre-rolls. How are they supposed to do that if they have to? Are they supposed to buy 23-ounce packages, unpackage it, roll it?
Right.
So there's a conflict of law here if this were to pass as well. So this needs some cleanup if they're going to try and push this forward. Anyway, that would be effective November 1st if passed. Senate Bill 1635, proposed by Senator Coleman also. This is pretty much identical to the House bill that we discussed early on, initially related to requiring verification that you are in compliance with building and safety codes, and creating this verification compliance ability for municipalities that if you don't conform with it, OMMA can suspend your license. So almost exact same language, exact same proposal as that first bill that we discussed.
Yeah.
Senate Bill 1747 has been proposed by Senator Garvin. This is a new bill. Again, almost identical to the bill I just went over, 1634, requiring flower products be sold in prepackaged form. So there's a very big desire for this to happen apparently. So same thing.
And I mean, when it comes to two bills that have very, very similar language and certainly a same purpose, really where it matters is us paying attention to the legislative process to see what language actually gets out of committee and onto the floor and maybe potentially passed and over to the other chamber, because the language will matter on what, the other bill was every flower product with the exception of concentrates. This bill is all flower products, doesn't even reference concentrates. And so it's going to be a question as to the language, as to how this will really apply, but this is one to keep, watching.
Right. Okay, Senate Bill 1748, also proposed by Senator Garvin. This would make getting a patient license for minors a little bit more difficult. It would require, which I think this is already the requirement, you have to have two physicians make the recommendation. But now it says that those two physicians can't be at the same location. One of them has to have been routinely caring for the minor for at least a year in person. Or if they were providing telemedicine, they would have had to have provided them services ongoing for at least 5 years. Or they would have, that minor would have to have a referral from a physician who routinely sees that child. So they're just upping the requirement, the due diligence of having a minor become eligible for a patient license. I thought it was interesting that it authorizes the executive director to promulgate rules specifying the qualifying medical conditions for minor patients. As far as I know, she's not required to be a physician herself. I'm sure that there would be some consulting with some medical professionals, but it just seems odd that that power is given to a non-physician. But yeah, I mean, we would also see if this passes limiting and specifying actual qualifying conditions, medical conditions for minor patients, which Oklahoma has, since the beginning of this, passage of State Question 788, it's sort of been known across the country that, we were one of the few states where there wasn't a list of required medical conditions. So we're seeing that, be imposed at least on minors if this passes. And then it would require that those qualifying conditions be the only conditions that a minor may receive a patient license for, and it would require an in-person examination of the patient by a physician for that. So.
Yeah. This is similar to a bill that I think was pending last session, or the first session of this legislative session. So I don't know how much legs this bill really has. It's interesting that we want two physicians that are not in the same building to review a child, particularly one that's been potentially a child that's been using cannabis as a medicine for, since passage or even before if they were going out of state. So it seems a little overreaching. Obviously you can tell that the legislature is very interested in protecting kids.
Right.
So,
we've got the child felony, child endangerment felony, and then we've got this. And I think one thing to keep in mind in that, the legislators need education on is that, and reminding of, it's not like parents just go into this lightly. It's not like we're out trying to get our kids high. That's just asinine, the reality is that, for example, there's a CBD product that is, FDA approved for child seizures. And the medicine that was being prescribed before that, one of the side effects was blindness. But, never mind that. Let's focus on cannabis. It's just, there's this lack of perspective. Are there really parents out there trying to go get their kids high? I highly doubt it.
I highly doubt it.
And taking away the ability of a parent to make these decisions for their children, this is a last resort for parents. And you're making the parents who are already dealing with an insurmountable amount of stress and confusion and concern and heartbreak over children who are autistic, who have seizure disorders. You're making them jump through more hoops just to get a plant-based medicine that causes less harmful side effects than blindness for their kids.
Yeah.
That doesn't seem like it's in the best interest of children when you really think about it. But there's, again, just this lack of education and a continued stigma of this plant. So Senator Garvin has proposed that. If you have any comments on that. And that last bill would go into effect January 1st of 2026. So you have some time.
Yeah.
But still, Senator Garvin has also proposed Senate Bill 1750, which is sort of along the same lines of the bill we just discussed, not so much as to children, but as to the requirements of these physicians. So this would require OMMA to maintain a registry of recommending physicians beginning January 1 of 2025 and a registration of by physicians with the OMMA. It authorizes OMA to conduct conferences, meetings, trainings that are deemed necessary for the collection and distribution of funds, of sponsors, and registration fees. That we'll talk about this all in a minute. Let me get this all out. Requires the executive director to promulgate rules establishing medical education and continuing medical education requirements for recommending physicians. Again, not a physician herself, but that's okay. And beginning in January of 25 would require employees to comply with education and continuing education requirements to maintain eligibility for those employee credentials that you all just applied for. And it would deem it unlawful to host or advertise medical marijuana related events requiring admission fees or open to the general public. So just in general, no more medical or marijuana related events, other than for the purpose of providing education to a physician on the list of approved providers and as permitted by the appropriate licensing board. And the OMMA would be able to promulgate rules to issue or deny permits for events not hosted directly by the OMMA and not related to education of providers. So there's a lot here. I know it was brought up in our review of this with the Bar Association that this might be considered a log rolling bill because there's different, when you pass a bill, it's supposed to only be on one topic. And we've got, this topic of physician requirements. We've got this topic of public events. It's sort of they're trying to make it all relate, but I don't really think it does. So there's a lot here.
They're trying to tie it all to cannabis education, essentially, by converting things like Cowboy Cup or Harvest Fest into an education event, as opposed to an event where, frankly, business owners can go and conduct business and talk shop.
Yeah.
And so that language was actually in a bill last year that died. Many of our operators out there in the industry may remember that there was an event bill last year that Senator Garvin had proposed that would essentially have killed all of these events. This seems to mirror the same language. It seems like it's been revived. Don't know where it'll go, but you can clearly see they're trying to couch it as education, far overreaching, and I think that there's a lot more work that needs to be done if this bill is actually to go into law.
Well, and I think the implications of it haven't really been thought through either. I mean, right now, you and I are sharing information about the industry. I mean, is this considered an event? How many people have to be present at an event?
Yeah,
I mean,
it's a good point.
And, if there are physicians even who are not yet registered, but considering becoming registered, this only allows for physicians that are already registered to receive the education. So, yeah, this needs a whole lot of work.
It needs work.
Senator Garvin has proposed that. So if you've got comments, be sure to share those. One more from Senator Garvin, Senate Bill 1753. This would be a new law. It would require the executive director of OMMA to promulgate rules to limit the THC serving size of edible medical marijuana products sold in dispensaries not to exceed 1,000 milligrams per package. It would also place limits, on minors and prohibit them from using vapes. I'm assuming minors just wouldn't be able to buy vapes under their patient license, a minor patient license. And then it would require OMMA to establish rules requiring dispensaries provide educational information to patients regarding potency, dosing, physiological impacts pertaining to usage and consumption. And that would be effective January 1 of 2026. So just more concerns that marijuana is scary and dangerous, and we're going to have limits. The state's going to then take on the role as medical provider and
I think the biggest impact that this bill may have is it's a wait and see bill, right? If the bill goes into law, then we're going to wait until essentially January of 26 before rules are proposed that tells our dispensaries exactly what information they're supposed to provide to the patients. And the wait and see part of it is what I think would create everybody's concern, is really the genesis of everybody's concern without knowing what you're getting into.
Right, and it would put the onus on OMMA to put together these materials and that the dispensaries then have to distribute.
Right.
And so.
Right. The potency bill that's a carryover.
Yeah, that's been proposed potency. A few times.
We are one of the few states that doesn't have potency caps.
And 1,000 milligrams per package is still, that's a lot. So, okay, fine. I don't know that will affect everybody terribly. But yeah, these proposed rules and disclosures,
I see the bigger problem with our dispensary operators who are out there, and they're supposed to provide, educational information to patients regarding potency, dosing, physiological impacts. Is that considered medical advice?
Right.
There's a lot of problems with what information our dispensary operators are supposed to provide to patients and whether or not that's, is that treatment advice? Is that prescription and recommendation advice?
Right.
I think there's a lot of cleanup that will have to happen with this bill as well.
Well, and we'll get to the bill in just a moment, but there's more related to the burden that's being placed on dispensaries being proposed as well that this would impact too. So, but before we get to that, this is a pretty large bill, and it's my understanding actually that the AG's office is in support of this bill and maybe helped propose some of the language in this bill. It's Senate Bill 1939, proposed by Senator Paxton. From what I understand, there is a big push to get this pushed through.
This is a big bill.
Yes.
This is an important one.
And I suspect it will go through. And I think it is very important that some things be added or edited to this bill before it gets passed, because there are some things that are not considered in this bill. So let me just start. First, it amends Title 63, 427.14. It adds the proof of right to use of property as documentation necessary for your OMA license. So a deed release. Okay, fine. No big deal. Prohibits having multiple licenses of the same type on the same premises, except for grows with indoor and outdoor, and processing facilities used by multiple licensees. I don't know why there's this exception for processing licenses. That seems to be inequitably applying the law here, maybe making a special law perhaps, which is something else that we understand have dealt with as a challenge to that tiered licensing bill we referenced earlier. But also there's no clause that grandfathers in pre-existing businesses, which I think is absolutely necessary.
Yeah.
So that language really needs to be added. It requires proof of bond with application for grows, which is essentially, it's already a requirement, so okay. This part is real interesting, so I'm going to read this a little bit out of order. So, I'll read it in order. So it creates a late fee of $500 a day for renewal of your license past the expiration date. $500 a day. So right now, there was a bill that went into effect November of 2021 that added a grace period, essentially saying that if you renewed your license after the expiration date, you had 90 days to do that. You had to pay a singular $500 a day fine, but now it would be $500 a day. And it reduces that grace period from 90 days to 30 days. So now you're potentially looking at $15,000 if you're 30 days late in filing the renewal of your license. So, so essentially it's encouraging you to either get it done timely or don't renew at all. And on the subject of timeliness, it states that only license renewals submitted at least 90 calendar days prior to the expiration date will be considered timely submitted, and subject to the requirement that OMA review that application within 90 business days. Not that they're following it right now. Anyways, if not timely submitted, so that means 90 days before you actually expire, the license will remain unexpired during the business license renewal review. So unpacking that.
Yeah, let's break that down.
Yeah, so unpacking that means that first off, right now, you can't even log into OMMA to start the renewal of your license until 60 days prior to expiration. So that's the first problem. The second problem is that even if you renew your license before the expiration date, under this definition, it would still not be considered timely submitted. So that means the OMMA would not be subject to the requirement that they review your application within 90 business days. And it would also mean that your license would not stay active if you didn't submit the renewal prior to 90 days. So the OMMA can sit on reviewing your renewal for however long they want, and past your expiration date, it wouldn't have to stay valid. Now, I don't think this is going to pass the Administrative Procedures Act, because I'm pretty sure in Title 75 it says if you apply before an expiration date for any license issued by the state, it remains active until review. So this is in conflict with existing law. But yeah, I mean, what?
Yeah, the timing of this bill, if it were to go into law, is really what I think has the biggest impact, and frankly, negative impact on
Right.
the licensees. I mean,
And it's so confusing.
it's a little confusing, but currently, obviously, if this bill passes, you would expect to see the portal logins being extended beyond that 60 days to 90 days, so
At
that you
least.
could at least 90 days, so
Have to
that
be
you
more
could
than that.
file. You would expect that, but it's not in here. And
Right.
so, not submitting it timely and that somehow being benefit to the OMMA if it's not 90 days in advance of the actual expiration date seems a little onerous. It seems unnecessary considering this current licensing process
Moratorium
now
also?
and the moratorium.
Yeah.
I mean, I kind of understand what maybe they're trying to do with this language, but it just seems too arduous, complicated, and unnecessary, and needs a lot of work if we want to make it fit with what the industry is already doing.
As well as with the Administrative Procedures Act.
Correct.
I mean, this is a state-issued license. I don't see how they can just deem it not timely, even if you submit it before the expiration date, because that is in direct conflict with what the APA
Correct.
says.
Yeah.
So anyway, this would also immediately upon expiration of a license, if you still hold any marijuana product, the business owners and operators would be subject to a felony prosecution. And it would require all business license holders to require employees to be credentialed, which, okay, whatever, those are fine. But the real problem I see here is this attempt to change what's considered timely in the process for renewing your application. Also in this bill, and also maybe considered log rolling because we're shoving a lot into
There's
this
a lot
bill.
in this bill.
We have a new law being proposed. Now, I am actually in favor of this new law. It needs some work also, but it addresses a problem that we have brought to the attention of the OBNDD, and I suspect is why we've got a proposal on it from the AG's office, because this is a problem for several of our clients, and we have certainly made the agencies aware of this problem. So the new bill would prohibit the transfer of business licenses without written approval of the application to transfer by OMMA. The applications to transfer would require inventory be listed, and then the OMMA would then issue a conditional approval of that transfer. Applicants would also then submit all documents to OBNDD, including the conditional approval issued by OMMA. And then once OBN completes their review of the application for registration, then they would be required to notify OMMA. And within 15 business days of receiving notice from OBN that registrant was approved, OMA would issue its final approval of the business transfer, and OBN would approve that registration. So we see the creation of a actual ability to transfer an active license, which has been a hindrance, so I'm pleased with that. The big problem I see is just some missing language. And one thing that I think is missing in general, with OMA, we have this 90 business day requirement. Again, that's not really being enforced or followed necessarily. But OBN has not, from the beginning of this program, had any time restraints on it for reviewing registrations. So even though there's this 15 business day requirement that OMA approve that final transfer once they receive notice from OBN that you're approved, there's still no time requirement on how long OBN has to review your registration. And that is needed just across the board. Because, I mean, we have applicants who are still pending review from like 2022. and
Right.
the state's just missing money right now by not, getting these approved so that people have to pay their annual renewal. So
The most beautiful thing about this section is that we don't have a process right now, and this would create it, and it's necessary, particularly with what
Absolutely.
you're seeing in the industry. There's a lot of consolidation, there's a lot of attrition. People spent money on a license, now they're wanting to get out of the business or transfer into a different position, and they can't transfer their license because there's not really a process, and you're stuck in bureaucratic hell trying to actually transfer the ownership of the license. This solves that problem. And yeah, it needs some work, but this is a good start.
it is. And, I would also argue that it's probably not even necessary. I think the OBN could create its own pre-approval process right now. The language of the statutes that are applicable only says that they can't approve a licensee or a registrant who doesn't have that corresponding business license. It doesn't say that they can't review it. This sort of creates what we had discussed as a closing, so that everybody gets approved, and then you come to the table at the same time, and you're finally approved, and then that license and an OBN registration can be issued all at the same time, and business can continue to flow. So it is very much needed, and I do hope that it gets a little cleaned up, a few more details, but I do hope that this moves forward for the sake of many people who are stuck in limbo right now. It goes on to say that conditional approvals issued by OMMA will be revoked if the OBN registration is denied, that it doesn't authorize, a conditional approval doesn't authorize the applicant to possess or sell or transfer medical marijuana products. I think you could probably still operate under a management services agreement of some sort there. Make sure you consult an attorney if you are trying to transfer an active license. And of course, nothing in this section prevents OMA or OBN from denying your license application or registration. Then it would require new medical marijuana business owners to provide OMA with a detailed inventory of all product upon taking control of the business. I hope they realize that the inventory list disclosed at the beginning of this process and at the end are going to be different, because this is a product that expires, that gets sold, that goes bad, that gets wasted. And then any attempt to transfer a license or substantially all of the product outside of normal course of business without approval from OMMA would be grounds for revocation or non-renewal of the license. That's really frustrating to me, because right now there's really not a process to do it. And so that is the way that people are having to handle it right now. I guess if this passes, they're essentially saying, well, now you've got a process, you don't need to do that anymore. But anyway, the transfer fee would be $500, which I think is already the fee, and it would be limited to one per year. And it would go into effect this summer, July 1st of 2024. So.
Yeah, I think that's the most interesting thing, is this bill has so much in it, and it's not going to become effective in November. It's going to become effective just a few months after session if it's passed. And there's a whole lot of things that are going to, moving pieces that are going to have to be put into place within a couple of months.
Right.
So the time of effectiveness is really critical here.
Yeah, it is, and it would require OMMA and OBN to promulgate rules very quickly.
Very quickly.
To comply with this. So, okay, just a few more. Senate Bill 1945, proposed by Senator Hamilton, prohibits advertising medical marijuana products as safe or harmless, or in a manner that suggests flavored medical marijuana products are healthier alternatives to non-flavored medical marijuana products. I don't even know where this is coming from. I've never seen a flavored marijuana product be proposed or advertised as healthier than a non-flavored, but somebody apparently has that concern and has shared that concern with Senator Hamilton. So it would also, now I thought this was kind of funny, it prohibits the use of flashing signs, flags, banners, or tube men on the premises of a dispensary. So you can't advertise your own business on your own property in the way that you want. There's a limit to that. No more tube men.
No more tube men.
Yep. And then it would prohibit designs that would depict improved social status, physical appearance, or athletic performance. And it would also prohibit discounts or coupons for the purchase of medical marijuana. Really getting into the business's business with this.
Really getting into the business of business. And frankly, I think it's interesting about discounts and coupons. I don't know about you, but I get discounts and coupons from my health insurance company for pharmacy records for me to go get my, prescription medication. I don't understand why we wouldn't be able to have the same types of discounts or coupons
medicine.
available for this type of medicine.
Right.
But here we are.
Yeah, here we are. Okay, Senator Bullard has also proposed Senate Bill 1979. This is the one I referenced a minute ago that also has a large impact, if passed, on dispensaries. So it would require dispensaries to show employment of a dispensary manager to obtain a business license. Okay, well, the dispensary manager, however, would mean a person who is currently licensed pharmacist in good standing with the State Board of Pharmacy and knowledgeable in the specialized functions of medical marijuana product preparation and dispensing. I just want to point out that pharmacists make six figures. Like, they are doctors, they make six figures.
Yeah.
And if you go to a Walgreens, for example, you have a bunch of pharmacy techs who are probably handing you your medicine. There's one pharmacist on staff. You may not ever talk to them, but they're going to have to be employed by dispensaries if this passes. And it would prohibit anybody other than the dispensary manager from actually unlocking the dispensary area, providing the product itself, recording the patient's information, providing the educational materials. So essentially, only the dispensary manager would be able to touch the product, put the information into the computer system, do anything with it. You can't even use a pharmacy tech like you can at Walgreens. And this pharmacy manager, this dispensary manager, has to be certified by the State Board of Pharmacy, meaning they have a doctorate, and you're probably going to have to pay six figures to afford their salary.
And
so,
frankly, practically speaking, good luck finding a pharmacist that wants to step into this type of a role,
right.
Considering the federal government stance,
right.
considering it's still Schedule 1. This poses huge problems
yeah.
to dispensaries. My opinion is this bill has no legs. I can't imagine pharmacists really supporting this. I can't even imagine the Oklahoma Board of Pharmacy supporting something like this. But here we are.
But here we are, yeah. All right, if it passes, it would go into effect next year, January 1 of 25. And the last substantive bill we have is Senate Bill 1980, proposed by Senator Paxton. I know that this bill is actually supported by the OMMA itself. Yeah. This would define hemp-derived cannabinoid products to mean a product that contains cannabinoids that are extracted from hemp or resin, and it would include products meant for animal consumption. It essentially adds all cannabinoid products and derivatives into the definition of marijuana, specifically adding Delta 8 and Delta 10. And so there are a lot of people in the industry who have decided that dealing with OMMA, all of these bills, all of the rules, it's not worth the trouble. And so let's do hemp-derived products. Hemp is regulated by the feds. If the source has, less than 0.03% THC, it's not marijuana. You can, we see all these D8, D10 products on the market, as well as hemp-derived D9. It's this, sort of commonly known loophole. But here we see the legislature going, no more. We're going to pull that in to the definition of marijuana. You will also have to comply with all the other rules if you're trying to play that game and use that loophole. This is going to have a huge impact on a lot of people.
This will have a big impact. And I mean, you can kind of see, we all know about the problems that have existed with synthetic D8, synthetic D10, sure. THCA, and some of the problems that, with less above board companies would put out products that could cause harm because of the way they're synthesized or the way they're created. This bill attempts to address that.
Right.
For that, kudos. But as we've pointed out, it may conflict a little bit with federal law.
Yeah.
It may conflict a little bit with how these types of products are regulated. There's a big problem with how the language is proposed. You kind of understand where they're coming from, but this one's a sticky wicket in my opinion because of the way the federal government, the way the federal law is written, regulating hemp-derived products.
Right. With the Farm Bill, I know that the powers to regulate hemp are actually allocated to the Department of Agriculture in the states. So there's also a conflict of agencies, who really has the authority to govern hemp-derived products. There is a licensing process that you can obtain for both growing and processing, which you should have through the state ag department for producing hemp products. So Now we're going to circumvent federal definitions of what is considered hemp and try to regulate that as well. Seems
That's what it
like
seems.
a potential problem.
And the real practical impact, I think, if this bill actually becomes a law, is that, listen, businesses that are selling Delta 8 products, they're not going to sell them in Oklahoma.
Right.
That stuff's going to leave.
Right.
And then that creates the problem that the legislature, I think, attempted to address several years ago, which is we don't want people going out of state and spending their money out of state. We'd rather keep those dollars in state. But listen, if this bill passes, people are going to Texas to get D8, or they're going to Colorado, or they're going somewhere else. They're just not going to spend their dollars in Oklahoma.
Right. So we'll see businesses leave.
Yeah.
Okay, well, that covers all of the newly proposed legislation for 2024, the second session of the 59th legislature. We will do a separate segment going over the 2023 bills that are still up for debate. I'm going to review both the status of these bills and those bills collectively in the next session that we do here. Things change weekly through the legislative session. This is based on a review as of February 12th. There may even have been some changes since that time. So just please keep that in mind, that this is an ever-evolving, ever-moving target through the legislative session, which ends at the end of May. So we'll be updating you again soon. Thanks.
Thank you.